Good morning or good afternoon, depending on where you may be joining us today. Thank you for attending today's presentation, The High Stakes of Workplace Drug Testing Cannabis Law Updates. Although this webinar is hosted by Cisiv, a global provider of compliance-driven human and capital risk management solutions, some of you may be joining us from one of our family of brands. Whether you signed up through PreCheck, Driver IQ, or other divisions, thank you for joining us. Nick, can you go to the next slide, please? Before we get started, I wanted to review a few housekeeping items. Due to the high volume of attendees, everyone will be muted to ensure the best experience. If you experience any issues during the presentation, you can interact with us using the Zoom chat pane. This presentation is being recorded, and we will share the recording and webinar slides after the webinar with everyone who registered. If you have any questions for our presenters, you may enter them in the Q&A tab, and we will try to address them at the end of the presentation. Today's webinar has been pre-approved by both HRCI and SHRM for 1 hour of continuing education credit. We will include the credit information and the follow-up email once the webinar recording is available after today's presentation. Also, please keep in mind, this presentation is intended for informational purposes only. Neither this presentation nor the material presented during the webinar should be construed as legal advice. Thanks again for joining us today. Without further ado, I'm pleased to introduce our speakers, Bill Judge and Nick Hartman from Drug Screening Compliance Institute. Bill and Nick, please take it away.
Yeah, thank you very much, Antique. Thank you to the Cisiv family for hosting today's webinar, and thanks for everybody for taking the time out of their busy day to join us for the conversation. Hopefully we can get you some insights on, as Antique mentioned, the high stakes of workplace drug testing. We're going to pick a little bit on cannabis as it's probably the biggest issue, but we're going to touch on a few others. But again, my name is Nick Hartman, managing partner here at the Drug Screening Compliance Institute. And joining me is my colleague, Bill Judge. Of course, Bill is an attorney, very well-known and outspoken attorney in the workplace drug testing industry. We're not a law firm. Today's information should not be taken as legal advice. As you can imagine, everyone's unique or situation is unique, so make sure that you leverage the right resources and legal resources prior to taking any action based off of today's information. We have a pretty aggressive agenda for the webinar today. We're going to talk a little bit about some numbers and some data on substance use and why it's important and relevant to the conversation. We're going to dive into some details on new legal limitations that employers are facing, specifically as it relates to changing cannabis laws, the new concept for off-duty use of lawful products and how that impacts the workplace. We're going to talk a lot about oral fluid drug testing as an emerging testing methodology. Then, of course, we're going to leave you with some guidance and action items. We do have time at the end for some Q&A. We certainly encourage your questions. Go ahead and submit them to the Q&A box or the chat, and we'll try to address those throughout the conversation and, of course, at the conclusion of the webinar. So we're going to jump right into some data on why the heck this is an issue that's impacting our workplaces, why we're talking about it, why we're having this webinar. And of course, we always look to our friends at Quest Diagnostics, one of the leading laboratories in our nation processing workplace drug and alcohol tests. And every year they provide an insight into positive drug testing rates for our industry. I think, Bill, correct me if I'm wrong, they analyze somewhere around 50 million drug tests a year. Is that right?
Yeah, we actually there's in the workplace as a whole, we do about 50 million drug tests every year, and Quest does about 11 to 12 million of those. So they're clearly one of the largest, if not the largest player in terms of laboratories that are doing drug testing for the workplace. And so this data is not only relevant, it's very, very important.
Yeah, so of the 50 million or so drug tests that are done in the workplace, only a subset of that, what about 8 million or so, are DOT or federally regulated drug
That's
tests. Right. The rest are non-regulated drug tests. Of course, I'm making that distinction because federal law, of course, you can continue screening for cannabis. You must continue screening for cannabis by federal law. It's a Schedule 1 controlled substance. But on the non-regulated side, for the majority of these drug tests, they fall under state and local laws, which that's where things are getting a bit complicated, which we're going to talk about today.
Yeah, and a lot of times I might point out, Nick, that a lot of employers who do have employees who are regulated by federal law or federal contract, what have you, they view themselves as federally regulated. They're not. You've got employees that are federally regulated, but then you probably have, most likely have, employees that aren't federally regulated, and therefore you must consider the state and local laws that apply to those tests as well.
Yeah, it's a great distinction, Bill. So looking at the data that recent data that Quest put out, and for those that are interested, just Google Quest Diagnostics Drug Testing Index. They have an excellent source that gets really into the data. They also have a really cool tool where you can plug in your zip code and find the positive drug testing rates in your local area. But overall, according to the Quest DTI, the drug testing positivity rate reached a 20-year high of 4.6%. So about 4.6 of those 11 million or so drug tests that Quest processed tested for some form of illicit substance. Picking on marijuana a little bit, the general positivity rate for the general workforce increased over 50% over the last 5 years. And marijuana positives in post-accident testing increased over 204% from 2012 to 2022. And Bill, why do you think that is?
That's incredible. When you think about it, and Quest did a brief analysis of why that might be. We get calls all the time from employers who are considering dropping marijuana as a pre-employment test, dropping marijuana from their panels. And we warn employers not to do that, and we inform them that we feel that marijuana use by their individuals that are applying for jobs are going to show up somewhere else. And by God, here it is. Post-accident testing up 204%. Now, Quest suggests that's because of the number of employers that are no longer testing pre-employment. So it's going to show up someplace.
That's right. We have conversations all day long with clients trying to balance the labor issue versus their screening program and their strategy. And, we shy away from suggesting that they stop screening for cannabis pre-hire because, as you can see, the evidence is already showing that you're seeing it somewhere else down the line post-hire. So, and there's only a limited amount of jurisdictions that actually prohibit employers from screening for cannabis, which we'll get into great detail in our conversation a little bit later. But not really a surprising stat, but great evidence to show the cause and effect there.
Exactly.
In states that authorize the adult use of marijuana, positivity rates, not surprisingly, increased over 118%. And states that authorized its use for medical purposes, we saw nearly a 70% increase. Again, not a huge surprise there. You start authorizing the use for various reasons, and it's going to show up in drug tests. One of Bill's favorite stats here, in states with no legalized use of marijuana at all, we still saw almost a 60% increase in positive drug tests for cannabis.
You're going to see it everywhere. We'll show in a minute. There's only 2 states that don't regulate marijuana in some way or another. And yet it's everywhere. So
yeah, that's right. Now, we're not picking just on marijuana, although that'll be a big topic of today's discussion. Alcohol and marijuana sales, we saw that they skyrocketed during the pandemic as everybody was self-medicating. We're still seeing a huge influx of alcohol incidents and substance abuse issues with alcohol. It is the leading drug of abuse, or most common drug of abuse, I should say, second to cannabis. So it definitely should stay important. Also not shown here for a DOT statistic, the Quest DTI index showed a slight increase in DOT positives, which is pretty rare. It stays pretty flat in a federally regulated environment, but a slight increase in there. And then, of course, amphetamines and cocaine positives showed an increase. So it's not just cannabis and alcohol. There's other drugs of abuse that are being utilized prevalently. Now, of course, the reason why we bring this up is because these are workers that are in today's workplaces and potentially causing an issue, a safety concern. Obviously, this is prevalent. All these people are gainfully employed individuals. So shifting the conversation a little bit to how we're seeing a trend that's changing in our workplace drug testing industry. We've followed all the same rules for about 30 years. Urine drug testing was the standard. We're looking for past use. We're trying to qualify an individual based off of historical use. Well, the tide is changing, and it's all being driven by cannabis laws and legalization to now detect more recent use. We're going to be talking about a lot of legal terms today, like under the influence, impairment, off-duty use, lawful products, etc. But that's really where the trend of this conversation is going.
I can remember back in the early days of drug testing where we would be scolded for the use of the word impairment. Well, that's no longer the case now, since so many different changes in states' laws, the specific language of the state's laws. We have to look to the concepts that are actually in the legislation.
That's right. And we're gonna get into some great detail in there on really what that really means from the language of the law and how it impacts workplace screening. But just to kind of give a lay of the land here, there are currently 38 states, Washington, D.C., and a few U.S. territories that have authorized the medical use of cannabis for a wide range of medical reasons, from stuff generally like anxiety and chronic pain, all to debilitating medical conditions, cancer, etc. The states vary widely on who qualifies for medical marijuana. There are 24 states, Washington, D.C., and a few U.S. territories that authorize the use for anyone over 21 years or older. And there's also 18 states that authorize the medical use of cannabidiol or CBD, or what they also coined to be low THC oils. Again,
we're
for
going to have
various
to.
medical conditions.
Oh, sorry, Nick. We're going to have another slide here pretty soon because we need to start reflecting the states where CBD from hemp is available and legal, and now the states that are starting to recriminalize, and not decriminalize, but recriminalize the intoxicating components from hemp products.
It's not surprising, Bill. CBD kind of came out with obviously incredibly little regulation and oversight. You start seeing these different deltas, variations of cannabis like Delta 8, Delta 10, all these hemp derived. We see all the evidence all day long about how these products have far more THC concentrate in them than they're legally allowed to. But again, with little oversight, they're allowed to navigate in those spaces and be distributed into the world with again with little oversight. So
already this legislative session, we've seen a handful of states, your state in Washington included, that are starting to criminalize intoxicating components of hemp products.
Yeah. Yep, that's actually a really good segue. So, the trend of the law is what we're seeing as states and municipalities that are taking their cannabis laws and furthermore impacting the workplace, where we've probably had this conversation a decade ago, and most all drug testing laws, specifically the cannabis testing laws, had no impact to the workplace. That conversation is far different today, where you see states that had medical marijuana laws on the books, they're evolving or expanding to add protections for employees or those that use the medication or the medical marijuana in accordance with state law. We're seeing new states come out with laws, even on the adult use side, that are now enacting employment protections. So it greatly impacts the who, what, when, where, why, how employers can conduct drug testing, and more importantly, what disciplines they can impose on new hires and current employees. Now, Bill, again, we're going to talk about some lawyerly terms here, but the one we're going to talk about next is lawful activities or lawful products law. Can you talk a little bit about the history of lawful products?
Sure. Regulation and court cases related to an employee's lawful use of lawful products off duty. That was a hot topic in the 1970s. Essentially, it was built around the idea of employers trying to limit the cost of insurance products in their workplaces having to do with smoking. Okay. Well, a lot of state legislators passed laws saying that they were protecting employees' off-duty use of lawful products, cigarettes, or tobacco. But at that time, or during those times, no one would have ever anticipated that someday marijuana would be legal. Well, here we are. So now we've got a growing number of states that are passing laws or already have laws built into their adult use of marijuana statutes that say employers can't discriminate against someone's off-duty use of a, quote, lawful product. And they include cannabis among those lawful products.
Yeah, so a smoking cessation, or like I said, an anti-nicotine screening prohibition, now kind of cannabis is falling into that same category, and it's having some pretty big impacts on workplace drug testing. And we're just going to talk about a few examples here. There are some states and cities that are prohibiting employers for testing for marijuana as a condition of employment. So for pre-hire drug testing, the states you see there specifically have laws on the books that prohibit employers for screening for marijuana to some degree, which we'll get into some of those specifics here in a moment. New York State and the city are even have different rules as to when you can test for cannabis. For at the state level, they prohibit you for testing for cannabis use outside of having reasonable suspicion. So a supervisor needs to have signs and symptoms of potential drug use before they're allowed to screen for cannabis. And within the city limits of New York City, marijuana testing is prohibited, but there's safety sensitive carve out for specific job types where there's an exceptions where employers can still screen for it. But you start seeing the dynamic there that it's at, the state level and granular down at the local level.
And unfortunately, people take this in general terms and they start thinking in terms of, oh, we can't, quote, test for marijuana. Well, that's just not the case. As you see from the screen here from this slide, there's only a handful of jurisdictions that limit or prohibit testing for marijuana. Most of the limitations in the states are related to discrimination against marijuana users. Big, big difference.
Totally agree, Bill. And this is really where we're evolving and tracking and keeping an eye on this and assessing different states' laws and their impacts, because we talk about off-duty use.
Yeah.
The 8 states that are listed there that limit or prohibit employer action or discrimination against lawful marijuana use. So it doesn't say that you can't test, but it's limiting what actions you can take based off of a positive drug test for marijuana.
Right. And so if it says you can't discriminate against someone's off-duty use, okay, what does that mean to you? Doesn't mean you can't test. You can test, but then if there's a positive, you have to go that next step of having that interactive conversation with someone to determine whether or not their continued use of that substance means they can't safely perform their job. So we encourage people to continue testing where permitted. And then to make those decisions as they move along to determine if performance of a job can be done safely.
That's a great point, Bill. And we kind of lose sight of it a little bit, but medical marijuana, specifically for medical marijuana in this conversation, but we saw how employees that are authorized to use medical marijuana were experiencing being fired or terminated for whatever reason, and they bring a lawsuit. And they try to sue the employer because they were discriminated against since they're a medical marijuana patient authorized under state law. The Barbudo case, which I'm going to have you give us a little bit of insight on, kind of put that right at the forefront, where some states have protections for employees using medical marijuana. Other states have zero protections for employees using medical marijuana. However, you mentioned it earlier, taking that additional step to address whether or not the underlying medical condition for which they're using cannabis can be reasonably accommodated in the workplace or not before taking adverse action is a huge step, a critical step.
Absolutely.
So talk about Barbudo real quick here.
And as you mentioned, the Barbudo case in the state of Massachusetts, it was interesting because as these court decisions came out, one of the early issues in these court cases was, does the employee or applicant who was denied a job, do they have a right to sue? Did the legislature specifically or by implication give them the right to sue their employer when they didn't get a job or when they got fired? And the courts were basically split on the question of whether they could sue. And in Massachusetts, the Supreme Judicial Court in the Barbudo case said, no, you don't have a right under the state's medical marijuana law to sue your employer. However, you do have a right to sue under our state's disability discrimination law. for the underlying medical condition for which you were using marijuana. So they took away the right on one hand, they gave it back on the other. Kind of interesting, free legal advice from your state Supreme Judicial Court. But the point being that you have to be very careful about how these laws are written so that you can determine what causes of action, if any, can be taken against you as an employer. And there's a huge difference between whether you can sue under the state's medical marijuana protections or the state disability discrimination protections or some other cause of action that might be available to you.
It's a complicated issue, and our recommendation for employers that are in states that authorize the medical use of cannabis for various reasons, make sure you have comprehensive job descriptions drafted. In a scenario like this, where you receive a positive drug test for cannabis and the donor, in this case, the employee or prospective employee in this case, says that they have a medical marijuana card, give them a copy of their job description, their comprehensive written detailed job description. Send them back to the certifying medical physician that authorized them to use marijuana under state law, have that physician sign off that they can safely perform the essential functions of that job under their use of cannabis. And then you can have the conversation on whether or not they can be reasonably accommodated or not before you take any adverse action to avoid getting in a similar scenario.
Yeah, and I will say that although, as we've said, there are 38 states that permit medical marijuana, 24 states that permit adult use of marijuana, virtually every single one of those state statutes says that an employer does not have to accommodate someone's use of marijuana at work. And that's the key. Don't have to accommodate the use at work.
Go ahead.
That's
a little Easter egg that we're leaving to you, the at work, because those words really do matter when it comes down to the language of the laws here.
Absolutely.
So it's essential for employers to understand the different language of the laws in all the states in which you conduct business in, to make sure you're not ending up as a statistic or on our next slideshow presentation. So jumping into pre-employment real quick, these states, as well as New York City and Philadelphia, employers are prohibited from screening for cannabis, or limited, I should say, limited or prohibited from screening for cannabis. Some of these situations and states have a comprehensive safety sensitive carve-outs. Some have a very general carve-out. We're going to talk very detailed about Washington and California's law. California is not on here because it doesn't discriminate against pre-employment testing, discriminates against taking any adverse action based off of a test. So jumping into it, California and Washington specifically prohibit employment action if the drug test reveals non-psychoactive marijuana THC metabolites. We're starting to get really detailed here, Bill.
Oh, yeah. And there are other states, but are in more ambiguous situations like New Mexico and Arizona and a couple of others. So North Dakota. But you have to be real zeroed in on what the language actually says. And here you have Washington, California, that basically say you cannot take action unless you find essentially the psychoactive component, Delta 9, tetrahydrocannabinoid, then you can take action.
You said that other states are starting to follow suit or have similar language on the bill, but those are essentially applied when they're talking about off-duty or while at work. They're using those types of terms, where you have states here, state legislators, lawmakers in California and Washington starting to identify the baseline for what the heck that means, the determination between off-duty use and lawful use of these products. And you'll see that when we get into the example here. But just an important distinction: Washington's law only applies to pre-employment, while California's law actually applies to all reasons for tests. Connecticut has a similar case where, again, testing is limited or prohibited outside of reasonable suspicion, post-accident or injury, or approved random programs. And the trend that we're going to be talking about here is that testing cannot include any other cannabis metabolites, which is very common in our work, has been very common for over 30 years in workplace drug testing. All right.
So, and we're going to get into California's law here right now, but there was a question that did pop in about basically what amounts to safety-sensitive carve-outs in some of these states. You have to look to the specific language of each of the states' laws to see, first of all, is there a carve out for any type of safety sensitive job? And then if so, what is it? And so you'll see that right now here in the legislation related to California. Because AB 2188 basically took effect January 1st of this year. And the legislative findings we thought were kind of interesting, because they basically said that THC, or tetrahydrocannabinoid, is the chemical compound in cannabis that is indicative of impairment. Well, there are a couple others, but okay, that's the one that they found to be most important. They also indicate that the intent of drug testing is to identify employees who are impaired. Well, that's a new twist, because up until just recently, the intent of drug testing was only to determine presence of a substance, not to determine that someone was impaired. Now, certainly in California, Washington for pre-employment, and some of these other states, determining impairment is important. Okay. So, and then moving on, you can see that what is now AB 2188 has been incorporated into the government code section 12954. And it basically provides that it's unlawful for an employer to discriminate. Again, note this, the distinction here. Doesn't say you can't test. It says you can't discriminate against a person in employment making decisions based on either the person, their use of cannabis off the job. So here you have a state that specifically addresses off-duty use. But it goes on to say that the law does not prohibit an employer from discriminating and hiring and so forth based on a scientifically valid employment drug screening test method. Okay. So what does that mean? Well, we're talking about, the test methods that are accepted today, oral fluid or urine testing and so forth. But you have to then look to the second step here, where it says an employer required drug screening test that has found the person to have non-psychoactive cannabis metabolites in their hair, blood, urine, or other bodily fluids. Now, Nick, where are we going to find the quote non-psychoactive or the psychoactive components of marijuana? Is it going to be found in urine? Is it going to be found in oral fluid? Is it going to be where's it going to be found?
We're going to let that hang with all our audience for a little moment here, and we'll get to that. But you're absolutely right. This is changing how cannabis testing is happening for workplace drug testing. It's flipping the script a little bit. Let's talk. We talked about safety sensitive exceptions a little bit, where employers can find a little bit of relief for specific job duties that are exempt from these laws in states that have put forth some form of safety sensitive exemption. California did not impress in that case, right, Bill?
That's right. Essentially, we every time we advise them of something, they ignored us completely. But you have a safety-sensitive carve-out for the building and construction trades. Someone asked in the chat or in the Q&A here while we were talking about other types of what would certainly be considered safety-sensitive jobs. Those weren't specifically included. So unfortunately, those are going to be left to the courtroom.
Yeah, California essentially only excluded from this new law the building and construction trades. Of course, anybody that has to follow federal DOT laws, federal regulations, contracts or grants are also exempted. But building and construction trades was the only safety-sensitive specific industry carve-out on this. And of course, the legislator did not define what that means.
Right.
So I'm sure there'll be a future challenge to that. But again, the point we wanted to make is that in California, you're not limited for testing for cannabis. You're limited on discriminating based off of test results.
Right. So if you're in an industry and you believe there's a safety sensitive component to what your folks do, you're going to unfortunately have to argue that in order to be successful.
I know the state of California is working to expand their safety sensitive exemptions, but I believe the scope is limited to first responders.
It is
that kind of stuff. So again, we'll keep track as that continues to evolve. There is also a law on the books in California related to this, where you actually cannot ask a applicant if they've ever used or been accused of a cannabis related crime. So make sure that you're excluding that on your application.
Be real careful, because we just saw a case recently where the materials, the documents that an applicant has to fill out asked about that. It hadn't been revised yet, so be careful to make certain that all of your pre-employment materials, questionnaires, etc., don't offend what is called SB 700, which means you can't ask about off-duty or past use of marijuana.
Right. Shifting over to the great state of Washington, where I'm sitting at right now, SB 5123, again, went into effect the same the first of this year. And very similar to California, except the only changes or differences being it's limited to pre-employment, but they're still using the legalese that in here, the non-psychoactive cannabis metabolites. It's obviously still allows testing post-employment for cannabis and cannabis metabolites. So again, this is just limited to pre-hire. And if we look at the safety sensitive exemptions, the list was far more robust. Federal government, anything that requires a federal background check, obviously law enforcement. Of course, you got to have the airline industry in here because it's our friends at Boeing in the great state of Washington. But look at letter G here. They did include somewhat of a general safety sensitive carve out for employers by defining a safety sensitive position for which impairment while working presents a substantial risk of death. Such safety sensitive position must be identified by the employer prior to the applicant's application for employment, meaning they must have a job description already defined that is safety sensitive and make sure they put that in the hire posting.
Well, first of all, there are all kinds of jobs that are safety sensitive that don't necessarily involve a substantial risk of death, but clearly this also shows the importance of all of your pre-employment materials, your job descriptions, and so forth, to be very specific about identifying a position as safety sensitive.
And as a couple of research nerds this is all we focus on all day long. This is absolutely a trend that we see continuing in states that are continuing to authorize the adult use of cannabis, looking at their laws and revising them. So again, this is something that employers need to be prepared for right now and for the future. So Bill, we're going to talk a little bit about the science of cannabis testing, and we're just now catching up. There's just starting to learn a lot more about cannabis testing in the last recent couple of years here. But a quick science lesson from a lawyer on how cannabis digests in the human body.
Well, I am a lawyer, but I also was dumb enough to own a laboratory for a short period of time, so I guess I could speak to this issue. When I first got into drug testing from a litigation perspective, I was representing laboratories, and this is where I learned a lot about the science of drug testing. And it's important for the discussion about off-duty use versus being able to detect impairment and that sort of thing to understand how marijuana works. How does cannabis work in the body? Well, if you use cannabis, it breaks down into your system first as a substance known as delta-9 tetrahydrocannabinoid, or THC. That within a matter of hours breaks down to something called hydroxy THC, which within a matter of another few hours breaks down into another substance called carboxy THC. What's important to note, however, is that it is delta-9, the THC, and hydroxy THC that are psychoactive or impairing. Carboxy THC is not impairing, but delta-9 and hydroxy are out of your body within such a short period of time that what we've traditionally tested for in our laboratories is carboxy, because it attaches to body fats and remains in the body for quite some time. All kinds of theories and studies about how long that is. But it can last for a matter of hours and days, and some people would argue even weeks. But carboxy is not psychoactive. It's a non-impairing substance. So for those of you in California and Washington and in certain circumstances, New Mexico and North Dakota and Connecticut, you can't use a carboxy THC result to take action. You have to find delta-9. Where do you find that? Well, it's going to depend on the test methodology you use, right, Nick?
Absolutely correct, Bill. And that's why things are changing so dramatically over the last 30 years. We were used to urine as the golden standard, pun intended, for drug testing. Where that's not going to fly anymore with the language of the laws because as it exists right now, as far as I'm aware, you're not able to detect Delta 9 THC in urine or hair. So you're going to be looking to sample types like oral fluid, which are absolutely growing in popularity because of its ability to isolate and detect Delta 9 THC, and because it correlates more recent use. And as you mentioned, Bill, drug testing was originally designed to detect the presence of substance, not to determine if someone's high or under the influence or how high they are right now. The fact that the labs are testing for carboxy THC is because it was easy to find because it
Right.
sticks around forever. Um, where you typically have most drugs of abuse with about a 1 to 72 hour detection time period, depending on method and some other variables. But as you mentioned, carboxy THC is fat soluble, it sticks around, you can find it in urine. But again, with today's testing, especially in states that are distinctively using words like non-psychoactive metabolites of cannabis, they're referring to making sure that you identify Delta 9, uh, the substance as a substance before you're taking any adverse action.
Right. Now, we
So,
just recently, jump in real quick. We recently did a survey of all the states, the 38 states with marijuana, medical marijuana, and 24 with adult use. And we found that there are about 8 states that specifically detail limiting employers' ability to take action against an employee for their off-duty use of marijuana. But there's 28 states that limit employer action to when they find someone using or under the influence at work. Okay, so by implication, that's essentially protecting off-duty use.
I mean, again, you're using big legal words here, Bill. As the lawyer, you're using under the influence and impairment. As it exists right now, there is no methodology, there's no set per se limit that exists to determine if someone's impaired or under the influence of cannabis. And I really think we're years away from something like that coming because the science of cannabis is so unknown and complicated.
And unfortunately, there's only a handful of states that actually, although they use the terms all the time, impaired and under the influence, there's only a handful of states that actually define what that means.
Even on like the criminal side for DUID of drugs, it's being challenged where convictions of DUID for cannabis are being overturned because the labs looked for carboxy or identified carboxy THC, not Delta 9. So even on the criminal side,
Like
the flipped the scripts being.
Arizona Supreme Court recently threw out a DUID conviction because they found carboxy THC and not Delta 9.
And states are using urine and states are using blood and states are trying to set per se limits, but it's not really backed by the science as we're learning a lot more. And just to give you an idea on a chart, some people like charts, but you see the very bottom line there, which is depending on what study you look at, the average impairment time for someone ingesting THC. Of course, that would vary whether it's smoking, vaped, or whether it's an edible or whatever. But you see the different testing methodologies there. Saliva showing the most recent use. Breath is on there, of course, because it is an emerging technology that's being implemented into our workplace drug testing for the very first time in our country. They use incredibly sensitive testing for picograms versus nanograms, and there is a lack of of case law with the use of breath testing. So we'll see how breath evolves. But right now, saliva or oral fluid testing is the best testing methodology you can use to determine most recent use, and is the only method that we're aware of, aside from breath, that can identify specifically Delta 9 THC. You cannot identify that from what we're aware of in blood, urine, or hair.
And saliva testing, oral fluid testing, long-standing science. So it's got credibility to it.
Yeah, well, let's talk about that a little bit, Bill. So the benefits of oral fluid testing, you mentioned it's been used for almost over a decade, I would say, in workplace drug and alcohol testing. Definitely not as prevalent as it is now or will be here in the future, but tons of benefits that come from oral fluid testing. The top 5 or 6 here being that it has the shortest detection time period. Again, being able to correlate use while at work, while using a detection method that can detect these substances minutes after it's used. It's incredibly easy, quick, and less intrusive of a collection experience. You're not having to pee in a cup. You're not having to use a needle to draw blood, all those other different things. Oral fluid, obviously, one of the bigger things that we see from our industry, or the biggest wins, is that these collections are always directly observed. So they eliminate the opportunity, which is incredibly prevalent in urine drug testing today, where people are buying products or substituting their urine specimens during the collection process and finding a way to cheat the test. With an observed oral fluid collection, it almost virtually eliminates the ability for someone to alter or adulterate a specimen.
Well, it could also eliminate a lot of the legal arguments about invasion of privacy and that sort of thing. There's like 6 or 7 states that prohibit observed collections when it comes to urine collection, but not when it relates to oral fluid.
That's right. That's right. And even the gender issue that's out there with collecting urine samples definitely adds another alternative specimen. We will note that some states' laws specifically define what specimens are authorized to use under state law. Some may prohibit the use of oral fluid testing. They may also limit or prohibit the use of instant, rapid, or point-of-care testing products. And it's also important to understand the difference between instant rapid POCT products and lab-based testing. The cutoff levels of an instant drug test will be far less sensitive than that of almost, in some stats that we looked at, more than 10 times less sensitive as lab-based testing. So you got to understand what the cutoff levels are that you're dealing with those products.
One of the things that we've come across recently, and of course you and I, Nick, have been talking to employers for years about this, is having what we refer to as flex programs. Having a flexible program where you're doing one test methodology, such as urine for pre-employment, and then reasonable suspicion and post-accident would be based on oral fluid testing. A lot of that makes sense when you start to understand the timing and the test methodology capabilities that are available to.
That's a great point. What's the goal of your screening program, and breaking it up pre-hire versus post-hire? Pre-hire, you might want to see more historical use where you're allowed to by law. Where post-hire, I think more recent use, it makes them almost the most sense since you're taking action based off of an event like that. Now, just to wrap our conversation on oral fluid, for those that don't know, the Department of Transportation and Health and Human Services has vouched for the legitimacy of oral fluid testing, so much so that they're going to be allowing its use as an alternative specimen method for federal DOT testing programs. That's all still on hold right now until the labs get set up and then we have the devices that meet the new DOT requirements. So that's all on hold for the moment. But essentially, HHS vouched for the fact that oral fluid drug testing has the same science and court upholdability of that of urine. And I think it was noted there that DOT is using a 4 nanogram per milliliter cutoff level is the plan for DOT regulated testing. Right. So again, it's important to have that someone or an entity like that at a federal level vouching for the use of oral fluid, because it helps at the state level as well.
And of course, all these limitations we've been talking about so far, California, Washington, those apply to non-regulated employees, not the federal regulated employees. But as soon as the labs are available, DOT is going to permit your testing for oral fluid.
Yeah, that's exactly right. So, it's post-employment testing is critical. So when we have these conversations, the first thing that we tell our clients is not to just put your head in sand and avoid it. Take a look at what the science is. Take a look at what your TPAs and drug screening providers can help with. Take a look at the language of the law and just figure out a strategy on your pre and post hire screening. As you mentioned, Bill, some employers must still continue screening for marijuana. Federal DOT regulations, probably the biggest one. Companies operating off of federal grants or contracts, maybe a union or collective bargaining agreement still mandates the testing for cannabis. And then also compliance with voluntary drug testing laws as well. There's several different industry-specific requirements for screening for cannabis that remain. But again, understand that these laws are found at the federal level. These laws are found at the state level. And we're also seeing these laws at a city or local level. So make sure you're including all of those in your analysis of where you conduct business in. All right. I'm going to transition next to job descriptions. We talked about safety sensitive carve outs and employers that want to leverage those safety sensitive exemptions and be able to continue to screen for cannabis metabolites. So job descriptions, do you have them? Are they detailed? This gets brought up as it almost seems like a minor item that you would need as part of an HR thing, have a job description, post a job for hire. But these are incredibly important, especially as it talks about cannabis, and those laws are evolving and how we're determining someone to be safety sensitive. So we had one of our clients famous to us that said that we're a warehouse, all of our employees are safety sensitive. And Bill, what'd you say to that?
Well, the Supreme Court in Minnesota and the Supreme Court of Iowa recently decided that it's not a question of the environment that the employee is in, it's a question of the specific jobs the employee's performing. That's what determines whether safety sensitive exists or not.
Yeah, so don't just put on there this job is safety sensitive. Don't just say that this job is safety sensitive because we're in a warehouse. You're going to have to say that at any given time, this job, they could be jumping on a forklift, or they could be, if they're in like a hospitality environment, they're around hot liquids or knives or machinery that could cause injury or death that considers them safety sensitive. Those details will be incredibly important, not if, but when you're ever challenged under court law, the court of law, and justifying your safety sensitive distinction. All right. I know that was a lot of information, but we're going to wrap up the conversation with some guidance and action items, kind of summarizing everything we talked about, and then we're going to get to the questions as we see those piling in as well. At overarching all of this conversation is our friends at OSHA and the general duty clause, stating that each employer shall furnish a place of employment which is free from recognized hazards that are causing or likely to cause death or serious physical harm to its employees. Alcohol, cannabis, definitely right up there on those lists. So it is your responsibility to ensure a safe environment. Make sure that you clearly understand the language of the laws that are contained, again, federal, state, and local levels that relate to cannabis in all the states that you operate in, especially for employers that have hybrid work environments or have remote employees. Where they reside, where that work is being conducted, absolutely does matter. Make sure you create, implement, and routinely review your drug-free workplace policy. Make sure you have a stance on cannabis and the related consequences that will be imposed for policy violations. Detail your policies and procedures. Test methodologies, what methodologies you'll be using for what situations. Make sure that the policy and the procedures actually detail the policy and help your supervisors with knowing exactly what action steps to take in the heat of the moment. Again, make sure you've reviewed what drug screening methodologies and products you want to use, especially in states that are starting to limit employers from screening for non-impairing cannabis metabolites. Also, make sure you provided your managers and supervisors with training, not only on the policy, but also for recognizing the signs and symptoms of workplace drug use or reasonable suspicion testing. In my opinion, I think it's one of the most valuable investments you can make into your workplace is training your managers and supervisors on not only to identify potential situations where signs and symptoms of drug use is prevalent, but what action steps to take confidently to handle that situation from start to finish. Because oftentimes we see things go sideways, and there's certainly repercussions on that as well. I'll harp at it again. Make sure you have comprehensive job descriptions for all the roles within your company, especially for those roles that you're considering safety or security sensitive. Make sure you're defining those essential functions of the job. Incredibly important if you're ever challenged. And of course, regarding medical marijuana, make sure that you're prepared to engage in the interactive conversation to determine if an employee's underlying medical condition can be reasonably accommodated or not prior to taking any adverse employment action. Now, Bill, I know we only picked on cannabis today and the state laws, but this is just one of the focus items that we have in our famous wheel of compliance here.
And we understand that the audience has 8 million things that you're dealing with every single day. But please appreciate that this is what we refer to here on the screen as our wheel of compliance. There are all sorts of different issues that affect your workplace drug and alcohol program. And some of them actually are financially beneficial to you. For instance, the workers' comp rebuttable presumption of intoxication defense. We are strong advocates of that. There are 21 states now that offer a rebuttable presumption of intoxication. You should find out what those 21 are. And if you're in one of those states, please take advantage of it. But all of these issues that are represented on that wheel of compliance you see there on the screen are very important to understand.
Yep. And all a different webinar in itself, we should touch on all those topics, but they all play a role here.
We've got questions coming in like crazy, so we probably should get to them.
We'll go ahead and transition to our Q&A portion here. So let me go grab and see what we got.
Question here from an attendee. Can an employer send an employee for drug testing if it was reported by several staff that the employee looks like they were under the influence?
Abso-frickin-lutely.
And they are obligated to in their role, I would say. As long, we always prefer the supervisors or managers to be trained officially to recognize signs and symptoms. But if you have cooperation from more than one, that obviously is substantial. Making sure those involved detail out their observations in writing, what they saw, what they smelt, anything they heard that led them to that decision for conducting a reasonable or a drug test under reasonable suspicion, making sure they're providing transportation for that individual to a collection site to get tested and follow through afterwards is definitely important.
A couple of things. Never send anybody you suspect of using drugs or alcohol anywhere. Take them, get them there. Okay. Secondly, you don't have to wait till somebody is falling down drunk to have them tested based on reasonable suspicion. The Supreme Court defines reasonable suspicion as something more than a hunch. That's it. You can test.
Yeah. Good question. There was a question I saw in here about a Washington state employer who's federally funded. We're obviously navigating the new Washington law. Do you have any advice there, Bill, for someone who's federally funded?
Yes, the Washington law, the limitations we talked about state by state don't apply to federal grantees or contractors. You have to look to see what is required of you. Typically, it'll show up in the bidding process, and you'll be asked to sign a drug-free workplace statement, most likely. But if you're a federal contractor, then you're most likely covered by federal rules. Each situation's different, so I can't make a generalization of that. But federally regulated federal contractors, grant recipients are most likely going to be covered under federal law. And we remember that marijuana remains a Schedule I drug, at least at the moment. There's a movement afoot to try and reduce it to a Schedule III. Many states like Minnesota and others have already reduced marijuana to a Schedule III substance. Does that change the safety issue? I don't think so, just because you reduce the classification of it. But anyway.
I'd also add, just be careful that make sure that you're applying that only to those employees that are operating under the federal grant. If you have a subset of employees that aren't operating under the federal grant, those rules will be treated differently.
That's absolutely.
Bill, here's this. This is I saw this and I have to say it. So, is the odor of cannabis something more than a hunch? Which, of course, is your favorite coin there.
So far, yes. Now, on the criminal side of things, odor alone in certain states now is not sufficient for a law enforcement officer to make an arrest or make a stop of a car, for instance. But that is a quick changing issue in the criminal side of things. But so far in the workplace, odor is still enough to take action. Yes.
Great question. Anything else you saw in there, Antique?
What about for in healthcare for hospitals or medical facilities that conduct pre-employment testing? Are they moving to oral?
We just worked with a very, very large nationwide healthcare group, and they're updating their policy, as everybody should, to reflect the different types of test methodology so that it can be applied appropriately in the different states like California and Washington and New Mexico and North Dakota and so forth. But yes, you can still test for marijuana. There has to be a balance with the realization of your need to fully staff people. What I've seen and would be helpful in the healthcare industry is to have seminars, have discussions with the the professional staff so that they understand what the issues are.
Yeah,
but talk about it realistically. Yeah.
Yeah, but absolutely the switch to oral fluid is on, and whether
Yes.
that's being done pre-hire versus post-hire, every employer is kind of justifying or analyzing where that applies with their specific program. But we absolutely, in our opinion, see oral fluid taking market share over the next few years here, more so than urine because of its applicability and its ability to identify Delta 9 and more recent use of illicit
Yeah,
substances.
the DOT predicts that it will take as much as 45% of the drug testing share.
Yeah, we're also working with a group, full transparency, that we're partners with a firm called Buzzkill Labs out of California, and they're working on an oral fluid drug test that actually utilizes chromatography, something that's typically stationed in a laboratory, but they're bringing that technology into a rapid or instant test oral fluid test application, which we think is going to be one of the best tools for employers trying to navigate this issue. I think they're going to market this month, so more to come on that as that evolves. And there's plenty of other providers out there with cognitive apps that, again, might help you establish reasonable suspicion. They might help you get to that point, but ultimately, a drug test is going to happen before you can take any adverse action on employment action.
Yeah, what we love about the Buzzkill test methodology is that when you get a result, you get a result for Delta 9.
Only Delta 9, no cannabis metabolites, and it actually distincts between smoking and edibles, which is incredibly challenging
Yes.
as we're learning more about the science. All right.
Another
More
one,
questions? We got a
is
lot of
there
questions and chats there.
is there a way to test for CBD versus THC,
Yes.
or do they both test positive without distinction?
That's a great question. So, and going back to our conversation with lab-based drug testing today, we only screen for carboxy THC. If someone uses cannabis, CBD or cannabidiol, it'll never show up on a drug test specifically for cannabidiol. However, as we
Yeah.
talked about, the industry is incredibly unregulated. We saw all kinds of case law
Oh,
evidence showing that most, if not all, of the CBD products out there contain more elevated levels of THC than they're legally allowed to.
yeah.
It is possible for someone to use a cannabidiol product and test positive for THC, depending
Yeah.
on many different variables.
Yeah, that's the problem. A recent study showed that like 9 out of 10 products tested had elevated levels of THC. You think you're using CBD, but in fact, you're taking in THC. That's the problem.
Yeah, and laboratories can distinct between CBD and THC, but it's not commonplace today. I don't think you can have a drug screening panel that isolates CBD from THC. Maybe that'll evolve someday, but it doesn't exist today that I'm aware of.
All
I
right.
saw lots of questions for getting a copy of this slideshow. I'm sure that the team at CISA will follow up. You guys will get a
Yeah.
copy of the recording in the slide deck there.
Yep. Maybe one more question. How does this affect physicians and the credentialing of physicians, i.e., medical staff privileges?
Again, I
Well,
think you have to look to the language of the law, right? Does it specifically exclude them as a safety sensitive job or not? Bill, you want to add to that?
yeah, it also depends on the facility, the hospital group, each particular employer. I've been doing this 38 years, and I can tell you one of the first customers I ever had as a lawyer putting together a policy was for a hospital in Chicago. And they wanted to exclude marijuana testing for all of its professional staff. So, I mean, this is a longstanding issue in the healthcare industry, and each hospital has to address it on its own, reflecting what the law permits them to do. Do we
Right.
think that it's a safety sensitive position? Without question. Um, I would definitely be looking to oral fluid testing in the healthcare profession for sure.
And
All
there was
right.
a question whether oral fluid can still screen for other drugs of abuse. The answer is absolutely
Oh yeah,
yes. It has huge
absolutely.
benefits for cannabis testing because it can identify Delta 9, but still is prevalent for a multi-panel solution for recent use of multiple drugs.
All right.
Absolutely.
Thank you for joining us today, Bill and Nick. I'd like to thank you for being with us, providing us with such an informative and timely presentation on the latest cannabis drug testing laws.
You're welcome. Thank you.
If you have any questions about the topics that were covered today or are interested in receiving a complimentary assessment of your drug testing program, you may scan the QR code on the screen. As a reminder, we will share the webinar continuing education credit information as well as the recording and slides via email in the coming days. Thanks again for joining us and have a great rest of your day, everyone.
Thanks,
everybody.
everybody.